Hi, my name's David Haig. I was tased 10 times on December 18th for trying to present evidence in court proving my case. That evidence would also prove serious criminal conduct by state officials. Since I was unjustly prevented from presenting the evidence in court, I'll do so here. This is a memorandum opinion by the Alaska Court of Appeals dated December 21st, 2016. In it, the Court of Appeals addresses my claims of prosecutorial misconduct and statewide corruption. The court says Haig alleges that he's a victim of wide-ranging conspiracy intended to frame him in order to protect the infant wolf control program from program-ending scandal. To this end, Haig claims that the state attorney is responsible for prosecuting his case, and that's what I'm going to be talking about here. Haig's own attorneys, Alaska Commission on Judicial Conduct, Alaska Bar Association, Alaska Public Defender Agency, and virtually every judge involved in this case have all colluded together in a vast conspiracy against him. Haig's allegations are, for the most part, simply unsubstantiated general allegations of wrongdoing without any specificity or support in the record. We therefore agree with the district court's decision to dismiss these claims for failure to state a prima facie case for relief. As we explained in LaBrake v. State, courts are not required to simply assume the truth of pro forma assertions of the ultimate facts to be proved when these are not supported by specific details. And the actual evidence that I presented, I've already presented them in number 1 and number 3 evidence packets that have the physical evidence for state attorney corruption and prosecutorial misconduct. So I'll go through. This is the briefing that I gave to the Court of Appeals. It's dated July 24th, 2013, which is almost 3 years before this memorandum opinion came out. In my briefing to the Court of Appeals, I state, in March, April 2004, by falsifying affidavits, warrants, claiming evidence was found, Haig killed wolves in Game Management Unit 19C, and correctly claiming Haig guided in Game Management Unit 19C. The state conducted 5 search seizures at Haig's home, lodge, property, and airplane. Haig asked when he could get the airplane back because he had clients coming in the next day. The state told Haig he would never get the airplane back and never informed Haig of his right to an immediate post-seizure hearing. Yet AS 2805-131 and Waste v. State, Alaska Supreme Court 2000, require immediate notification of the right to a prompt post-seizure hearing. My first attorney, Brent Cole, told Haig the state had given me immunity that compelled him to give an interview statement. Haig gave State Prosecutor Scott Leaders and Trooper Brett Gibbons a 5-hour statement interview about everything, and is recorded telling Leaders, Gibbons, Cole the wolves were not taken in Haig's GMU 19C guide area, but in GMU 19D, an area Haig could not guide in. Leaders, Gibbons are recorded requiring Haig to mark wolf kill locations in pen with digits on a map. Cole let State prosecute Haig about everything discussed in the interview statement and let State use Haig's interview statement to do so. Yet Alaska Statute 12.50.101 and State of Alaska versus Gonzales, Alaska Supreme Court 1993, prohibit prosecution for anything discussed in a statement interview given after immunity. The Fifth Amendment of the U.S. Constitution on Article 1, Section 9 of the Alaska Constitution prohibit compelling defendants to be witnesses against themselves, and Castigar versus United States, U.S. Supreme Court 1972, and U.S. versus North, D.C. Circuit Court 1990, prohibit any use of an immunized statement against the person giving the statement, even excluding anyone exposed to the statement from being involved in the prosecution. And it was Leaders and Gibbons who prosecuted Haig after taking Haig's statement. My first attorney, Arthur Robinson, sent a protest to prosecutor leader's office by fax, courier, and by urgent fax to prosecutors' conference leaders was attending. Leaders continue using Haig's statement in the charging informations and wrote a verified statement to the bar. He never used Haig's statement in any charging information, which is perjury. Judge Murphy sentenced Haig to nearly 2 years in prison, over $20,000 in fines, restitution, airplane property, forfeitures of over $100,000, and to a 5-year revocation of Haig's guide license, destroying Haig's life. No credit was given for the guide year given for the plea agreement the state broke. Murphy's sentence justification: Haig killed most, if not all, the wolves in GMU 19C where you were hunting. Apparently forgetting her chauffeur, Trooper Gibbons, had admitted this was known false testimony by him. Murphy also stated the politics involved, such as effects to the wolf kill program. Haig fired Robinson, couldn't find an outside attorney to go after Robinson and Cole. Cole was my first attorney, and hired Alaskan attorney Mark Osterman. Haig recorded every conversation with Osterman, from hire to fire. After looking at the evidence for a week, Osterman stated it was a disaster in it. What Chuck Robinson did was wrong. What Cole did was wrong. Robinson should have went after Cole. It is the biggest sellout of a client I have ever seen. When the Court of Appeals sees the sellout, they will overturn your conviction. It was ineffective assistance of counsel. Scott Leader stomped on your head with boots. He violated all the rules, and your attorney allowed him, at that time, to commit all these violations. I can't figure out why Chuck's protecting him, and we will sue for millions. Osterman stated everything should have been protested, and, quote, you didn't realize Robinson Cole was going to set it up so there, the state's dang dice was always loaded. The state was always going to win. Osterman stated the Bar Association protected crooked attorneys. Haig filed a bar complaint against Cole, who testified under oath that the state gave Haig immunity for his interview statement. Cole's witness, attorney Kevin Fitzgerald, testified Haig was given transactional immunity by the state for his interview statement, and testified that after Haig had given the interview statement, Leader stated the state would not be honoring Haig's immunity. Haig filed bar complaint against Leaders, claiming Leaders used Haig's interview in information charging Haig. Leaders, in a verified bar response, testified A, Haig gave an interview that couldn't be used against Haig, and B, he never used Haig's interview in the information charging Haig. Haig then produced the charging informations, all signed by Leaders, and quoting, David Haig's interview is reason to charge Haig with crimes. Although this proved Leaders illegally convicted Haig and committed perjury to cover up, the bar exonerated Leaders. Haig put wolf kill locations on a map during his interview, and this map couldn't be used against Haig. State had a duty to correct false evidence locations after it was pointed out to him. And this is what Brent Cole testified to in his deposition. Yet they never did. Cole didn't have a duty to protest the false evidence locations. The state would harm him. In other words, the state would harm Cole and his business if he tried to defend Haig. This is what Cole testified to during his deposition. It didn't matter that the state falsified evidence locations to Haig's guide area and then said the reason for charging Haig was evidence was found in Haig's guide area. Cole never represented Haig, yet Haig paid Cole tens of thousands to represent him. Cole expected Haig would be made an example of, and it was possible the state intentionally falsified evidence locations to Haig's guide area to make an example of Haig. Cole testified he told Haig to give up guiding prior to conviction and testified state promised to give Haig credit for this guide year. Yet state testified at Haig's sentencing they had no idea why Haig gave up this guide year. The state tried to title Haig's airplane to sell it. FAA refused, stating the judgment against Haig was not a judgment against the plane's owner, Bush Pilot Incorporated. 5 years after Haig's judgment, the state motioned Magistrate Woodmansey to amend Haig's judgment to include forfeiting the airplane owned by Bush Pilot Inc. And on June 8, 2011, over 5 years after judgment against Haig, Magistrate Woodmansey did so. Even after Haig pointed out this violated Alaska Statute 12.55.088 and State versus TM, Alaska 1993, which prohibit judgment modification on a motion made more than 180 days after judgment. And after Haig pointed out it's illegal to pronounce judgment against a legal entity without notice and opportunity to defend. Judge Bauman then denied Haig's appeal of this. After Haig claimed the map used against him at trial was the one he marked wolf kill locations on during his interview, Bauman ordered state produce it, but then never let Haig prove he put the kill locations on it. After state refused Haig a copy, he looked at Bauman's and found not only was it the map he placed kill locations on during his interview, it had a false game management unit boundary hand-drawn in pencil that corruptly made it appear kills were in game management unit in which Haig guided. A falsehood that exactly matched falsehood on all warrants, and a falsehood that exactly matched Trooper Gibbons' admitted false testimony against Haig at trial. Haig realized Zellers, during his interview, had pointed out to leaders and Gibbons a false game management unit pencil boundary on the map that corruptly made it appear the wolves Haig marked were taken in GMU in which Haig guided. So state knew the map had a false game management unit boundary on it that exactly supported their case before they used it against Haig at trial. And Peterson had to know it was false when he presented it to Bauman, Judge Bauman, and used it as evidence to dismiss Haig's post-conviction relief proceeding without ever admitting it was false. Meaning the state now presented known false evidence to Judge Bauman to oppose Haig's PCR. This also explains why state tried preventing Haig from obtaining a map copy and why a map copy was never provided to Haig before trial as required after his discovery requests. Brady, that's Supreme Court case Brady. Because Napu, Messerosh, Mooney, and Giles prohibit the state from using known false evidence to convict, Haig filed a 511-12 motion for immediate evidentiary hearing on newly discovering known false evidence presented during Haig's trial, and now to Judge Bauman. Bauman refused an evidentiary hearing on this, even though it meant Haig's conviction was invalid. Peterson claims state affidavits never indicated wolves were killed in same game management unit as Haig's Lodge, yet state affidavits proved this false. Peterson claimed Cole never testified Haig had immunity, yet Cole, in two different proceedings, testified Haig had immunity. And Fitzgerald testified Haig was given transactional immunity by state, and afterward leaders told Cole he was not going to honor it. Peterson claimed Haig's interview wasn't used in filing the higher charges in the amended information, yet both amended informations with the higher charges specifically use Haig's interview. Assistant Attorney General Andrew Peterson informed Haig the state would return the airplane if Haig agreed not to sue anyone. State harmed and threatened to harm Haig's attorneys if they tried to defend Haig. United States versus Chronic, U.S. Supreme Court, 1984. Haig's attorneys had interests and conflicts with Haig's, and this affected how they represented Haig. The state's threats and resulting conflicts explained perfectly all puzzling action-inaction by Cole, Robinson, Osterman, and even DeLifka. And this is the case law that proves how bad that is. And I'll read one of them. In fact, an attorney who is burdened by a conflict between his client's interests and his own sympathies to the prosecution's position is considerably worse than an attorney with loyalty to other defendants, because the interests of the state and the defendant are necessarily in opposition. The performance of defendant's counsel was constitutionally unreasonable, but more importantly, the evidence presented overwhelmingly established that his attorney abandoned the required duty of loyalty to his clients. Defendant's attorney didn't simply make poor strategic choices. He acted with reckless disregard for his client's best interests, and at times apparently with the intention to weaken his client's case. That's exactly what happened to me because the state threatened my attorneys with harm if they didn't side with the state. State used known false evidence testimony to convict Haig. The official court record was tampered with to remove Haig's evidence. State never produced requested pre-trial discovery, including trial map, which 9 years later was found to be falsified to make it appear wolves had been killed in Haig's guide area, the exact case used to destroy Haig's life. Useful falsehoods are particularly dangerous in a criminal case where the cost of a wrongful conviction cannot be measured in the impact on the accused alone. Such tainted proof inevitably undermines the process, casting a dark shadow not only on the concept of fairness, but also on the purpose of the exercise of the coercive power of the state over the individual. No man should go free nor lose his liberty on strength of false, misleading, or incomplete proof. U.S. versus W.R. Grace, 2009. Cole Robinson conspired to keep Cole from testifying at sentencing about the plea agreement State Cole conspired to deprive Haig of after he paid for it. Peterson told Cole not to answer incriminating questions when deposed, and that's Assistant Attorney General Andrew Peterson. Judge Joanides ruled an evidentiary hearing must be held to determine if Gibbons chauffeured Murphy during Haig's trial. Judge Bauman ruled on the merits of Haig's claims without an evidentiary hearing for Haig to prove the merits with evidence testimony, violating Haig's right to present evidence, due process, and equal protection of law. It is true, for purposes of determining whether a claim of ineffective assistance of counsel may be rejected summarily without affording the defendant an opportunity for an evidentiary hearing, the court must provisionally accept as true any facts asserted by the defendant. Bauman had to accept Haig's claims that he had immunity. The state blackmailed and conspired with his attorneys. His attorneys lied to deprive him of a fair trial, as true in deciding if an evidentiary hearing was required. It's clear Haig was unjustly convicted if he had immunity preventing prosecution. The state blackmailed and conspired with his attorneys, and or his attorneys lied to deprive him of a fair trial. So an evidentiary had to be given. State, Parker, Berry, and Wood, which are the Alaska cases. Attorney Arthur Robinson is recorded stating, "The good old boys of judges, attorneys, and troopers in Alaska protect each other when they commit crimes." Anchorage Daily News president publisher Patrick Doyle told Haig the evidence can't be published until arrests are made. Until then, those implicated will decide retaliatory lawsuits. Senator Thomas Wagner refused to even say out loud the FBI officials he wanted Haig to contact, handing Haig notes instead, cloak and dagger at its finest. Will this Court of Appeals grant relief? The reason you have still not resolved your legal problems is corruption. If they, the appeals court, do right by you and reveal, you know you have the attorneys going down, you have the magistrates going down, you have the troopers going down. This is sworn testimony from Attorney Dale DeLifka. After this court first unjustly denied Haig relief, more people, entities have been implicated. If this court didn't do right the first time, it sure can't now. A growing number have pledged to hold accountable those responsible, no matter what. They claim they aren't doing this for Haig. They claim until this evil is ended, they may be next. And until this is ended, our Constitution, for which so many have died and sworn to protect, isn't worth the paper it's written on. Your case has shades of Selma in the 60s, where judges, sheriffs, and even assigned lawyers were all in cahoots together. Also sworn testimony from Dale DeLifka. All concerned agree the following action must be taken at all costs. Exhaust all state remedies, as DOJ requires before prosecution. Document all delays, as it's certain DOJ's requirement is being used to, in conjunction with court delays, to starve into submission those aggrieved. Ask everyone possible attend the as yet to be scheduled oral argument in front of this Court of Appeals, as DOJ will be attending. Documenting how this court will twist facts and law to suit an increasingly tortured cover-up now embroiling itself and numerous others. and this was sworn to me. I declare under penalty of perjury the foregoing is true and correct. Executed on July 8th, 2013. No Republic, other official empowered to administer oaths is unavailable, and thus I'm certifying this document in accordance with AS 09-63020. In addition, I'd like to certify copies of many of the documents and recordings proving the corruption in Haig's case are located at www.alaskastateofcorruption.com. How much time we got?
20 minutes, 30 seconds.
I also have a reply brief which goes over many of the same things in there. I'll just show what else I gave to the Alaska Court of Appeals. And the Court of Appeals for the State of Alaska certified that it was received by them January 15, 2014, before December 21st, 2016. Just many more times I went over everything that happened. This is where Gibbons falsified warrants to search my home and seize my airplane. Swore to Judge Murphy that I killed the wolves in the 19C guide area. During required interviews, it proven to Gibbons leaders no wolves were taken in Haig's guide area. It was also proven to Gibbons leaders their map had a false 19C guide boundary that corruptly made it appear the wolves were killed in Haig's 19C guide area. And so over and over and over, I gave details to the Alaska Court of Appeals. And you can go back up there, Cass. So is it true, as the Court of Appeals claims, that I presented no details of prosecutorial misconduct by state attorneys? Or is it true I provided overwhelming details and the Court of Appeals had to lie that I didn't? To make sure evidence that proves state attorneys are framing people is not presented in open court where the state attorneys would be required to refute it. The video of oral arguments to the Court of Appeals also proves the Court of Appeals were presented specific details and evidence of state attorney corruption. This can be seen on YouTube under David Haig versus State of Alaska, with the actual map that the state attorneys falsified as the main exhibit presented. Thank you.